Okay, welcome back to another human resource video. We're going to continue on with the course Employment Law. This chapter, another important, very important chapter, like chapter 7. This chapter is Sexual Harassment, chapter 8. So another chapter that has its own dedication to this type of harassment that we're going to encounter in the workplace. Okay? We're going to go over a quick overview on what the chapter is covering, and then we're going to highlight some of the important parts of the chapter and what our professors want us to know. Okay, so our chapter checklist. We want to identify what constitutes sexual harassment, distinguish between two types of sexual harassment, which are vicarious liability and hostile work environment. Sexual harassment in a hostile work environment must be severe and pervasive to be actionable. Terms such as babe, sweetheart, honey are not severe, but may violate company policy. Harassment that is neither sexual nor covered under any suspect classification is not protected under the Civil Rights Act of 1964. Wording in law is very important, and this is how certain behaviors slip through the cracks in employment in the workplace because they don't fall specifically under any particular act. All right, so let's move on through the chapter. Okay, we're going to talk about the requirements of sexual harassment. 6 requirements must be satisfied for sexual harassment to exist. The victim employee must be a member of a protected class, man or woman. The complaint must be gender-related, i.e., female must assert there would have been no harassment if she were not a woman. The employee must not have consented to the sexual advances or participated in a hostile work environment. Harassment must be based on sex. The conduct must have had a deleterious effect on the employee's job. And finally, harassment must have occurred in the scope of employment. All right, so these are the general requirements that are required or must be in place for a sexual harassment case to be built upon. Okay, we discussed torts shortly, but we don't need to do that because we've already gone through tort in a previous chapter. Okay, so the next big section we want to discuss are vicarious liability. There are 2 distinct situations for which the company may be liable, which is vicarious liability, which is formerly quid pro quo, and hostile work environment. 2 categories of sexual harassment: instances involving supervisors, which are vicarious liability, and instances involving coworkers. That falls under hostile work environment. The difference lies in the supervisor's ability to affect the employee's job through a tangible employment action. Supervisor to demand sex exchange or something. A big portion of that also is power. Your supervisor or manager has wieldable power over your workplace environment. Okay. Sexual harassment behavior. Employers are also liable when they fail to institute preventative measures. So these are the different variables that your employer needs to have in place, or the workplace needs to have in place to protect everybody from these type of behaviors. The employer can be held liable when these provisions aren't put in place to protect their employees. Okay. Failed to institute preventative measures, so no sexual harassment policy. The next one is they condoned the sexual harassment behavior. The next one is they learned of sexual harassment and failed to investigate and or take corrective action. Okay. So the Title VII applies to employers with 15 or more employees. We learned that in the last chapter. Otherwise, the victim must file on state, local level, or file a tort against the offender. Okay, so another component of sexual harassment is that it must be severe enough to create an abusive work environment and disrupt the victim employee's employment. Okay, so casual comments or insignificant events that are isolated or happen only intermittently aren't considered severe. So again, certain terms of endearment, maybe looks, they might be hostile, they might be wrong, they might be unethical, but a lot of times they're not severe enough to barely be acted on. If the work environment becomes so intolerable because the employer refuses to remedy the situation and the victim is forced to resign, they can also claim constructive discharge. We discussed that earlier in Chapter 5, termination. And basically this is when the environment's so hard that you're forced out, okay? Okay. So we'll touch on some sexual harassment policy, a model sexual harassment policy. Sexual harassment is defined as 1, a sexual advance or request for sexual favor made by one employee to another that is unwelcome and is not consented to. And 2, touching, joking, commenting, or distributing material of a sexual nature that employee has not consented to and finds offensive. Sexual advance may be defined as embracing, touching, cornering, or otherwise restricting an individual's freedom to move with the intent of pursuing sexual intimacy. A request for sexual favors may be defined as asking an individual to engage in some type of sexual behavior, such as, but not limited to, sexual intercourse, oral sex, intimate touching, and kissing. Okay, and so that is our overview of our sexual harassment chapter. They give us some cases that we can look into for scenarios and examples, and some HR dilemmas that we can work through either as a group or individually, some scenarios, and a few more case problems. All right, hopefully this overview was helpful in giving you some background on sexual harassment and how it qualifies. Again, this is information. This is not to be taken as legal advice. For any legal advice regarding hostility or sexual harassment in the workplace, please speak with a professional attorney, an employment attorney in your state or locality that can help you with your problems. Thank you again, and please, by all means, subscribe to my channel. It's very important. The more people that follow, the more people I can interact with, and the more we all can learn.